Hi, my name is Robert Hetsler, and I want to spend a few moments just to talk to you a little bit about mediation, divorce mediation specifically, and how the process works with me and my practice. Before we get started with that, I do want to say that I practice as a divorce mediator, not a divorce attorney. An attorney by trade is an advocate who represents either party, provides legal advice to each of those parties, and represents them through the court system. A mediator, which is what I am, acts and operates as a neutral third party who doesn't offer legal advice to either party. Matter of fact, any mediator and all mediators are prohibited from providing legal advice. The thought process being that a mediator is neutral, doesn't represent either party, and both parties get to use that person pulling on their knowledge and experience to help them customize an agreement that works for their unique set of circumstances without the need to have a judge or someone else make a decision and control their destiny for them. The mediation process works this way. You would contact my office to set an appointment. You can do that via email or telephone call. We would then fax you or email you a questionnaire that would be completed in advance of the mediation. Then we'd set a time where we'd all three sit down, both spouses and myself. We'd sit down and we'd try to work through all the issues, find out if there's child support issues, child custody, alimony issues, anything of that nature, assets, division of retirement accounts, all of those things. If there's foreclosure issues going on, if there's credit card debt, all of those things that we all deal with on a daily basis. I've certainly mediated over 2,500 cases, and I'm familiar with dealing with all of those issues. So we would just work through the process by offering suggestions and solutions and helping you guys customize an agreement. Once a verbal commitment is made, whether that takes 1 session, 2 sessions, 3 sessions, I would go behind the scenes and prepare a document, a proposed marital settlement agreement based on the verbal agreement between the parties, email it to you guys. Once we've gone back and forth through email or phone calls and fine-tuned any changes, then we'd set a final appointment. At that appointment, you'd be prepared to sign that document after you've had enough time to digest it. And if you want to, you certainly have the right. I don't encourage or discourage it. It's your right to have an attorney review the document in advance. Some clients choose to do that, some don't. That is your personal preference. Once you come in for that final meeting, you would sign the document. At that time, I would have all the other required divorce mandatory type of disclosures from the Florida Supreme Court site, the documents that are required to be filed. We would go through all those. I'd assist you in preparing all those. I would notarize them all. Then I'd take it down and file it for you, and you would be divorced, depending on the county, between 45 and 60 days. I do also want to say something else, that although I am a licensed CPA, I do not and am prohibited from providing tax advice as part of a mediation process. But having said that, we can certainly use my tax knowledge and my accounting knowledge to try to customize agreement if there's alimony involved or retirement accounts involved or something that require, or businesses that are involved that require some specific financial knowledge. I'm certainly available to help and pull on my knowledge to help customize that agreement, with the ultimate goal being in mind to save money from the IRS's hands in a legal way and try to put it back in the family unit. I hope this helps you guys understand how mediation works. If you want to set an appointment, give me a call or send me an email. I'll be happy to help. Thanks.